delighted that you could come along to our webinar today. We're welcoming James Barnes from Cairns CLC, who's going to speak to us about disability discrimination in employment. During the webinar, you're welcome to type in a question in the question section just to the right of your screen, or you can also hold your questions to the end and we'll be asking then. So I'll hand over to James now.
Thanks, Kathy. Thanks all of you for joining me this afternoon. So I'll be covering disability discrimination in employment. So I'll just get cracking because we've only got an hour. I'm just going to whiz through the first bits. This is a standard template for PowerPoints in the Cairns Community Legal Centre, and it's really structured for ComEd, so this is where we begin. So look, with regards to disability discrimination, I'll just give a quick summary. Disability discrimination is being treated unfairly because of a disability. Today, of course, we're looking specifically at employment. So there's a multitude of legislation, and it's probably about 5 acts in particular that we're going to cover, the 2 main ones being the Commonwealth and the Queensland State Act. And some of the issues that pop up with disability discrimination, such things as reasonable adjustments not being made to accommodate someone's disability, or being refused employment due to an impairment, being dismissed after developing a chronic condition, and many others. I'm going to be taking you through the legislation first off. We'll be talking about some jurisdictional considerations. I'll be going through like practical aspects, so hopefully if any of you out there have an opportunity to do an advice with someone who instructs that have a disability discrimination matter, after this session you might be able to you know, identify the questions and issues, and even know how to progress or resolve or undertake one of these matters. So I'll just click over to the key legislation and body. It should really be bodies because there's more than one body here. Look, the Anti-Discrimination Act 91, it's Queensland. I'm just going to call it ADA. But the Anti-Discrimination Act, the key body that's associated with it is the Anti-Discrimination Commission of Queensland. There's also some provisions that matters that go on through the ADCQ may end up being referred to the Queensland Civil and Administrative Tribunal, that's QCAT. There's also the Disability Discrimination Act 92, Commonwealth, and of course that's just going to be called the DDA. And it leads on to the Australian Human Rights Commission. There's the Fair Work Act, and of course I'll be talking about the Fair Work Commission, the Fair Work Ombudsman. And for some people, it's the Queensland Industrial Relations Commission is going to be relevant a little bit further down the track. And of course that's the Industrial Relations Act 99 Queensland. Now, I really have to undertake the task of going through some of the differences, because the Commonwealth Act and the State Act, they're quite similar, but they do have these distinct differences. And one of the things that I've learnt with disability discrimination matters is it's really important to get your matter right from the beginning. In particular, once a matter has been referred to, say, the ADCQ, you have no opportunity to add arguments so I'm just going to kick off with, hang on. Hey, Kathy, can you hear me? Kathy? Oh, that's good. Whatever you did, I can no longer hear you. So, look, I'm just going to run down the definition of impairment in the ADA, found within their schedule. And so, under the ADA, impairment means a total or partial loss of a person's bodily function. It includes part of a body. It's a malfunction, malformation, or a disfigurement. It's a condition that results in a person learning slowly, so learning disabilities. It can be in relation to mental health issues, although they give a really wordy explanation, or it could be the presence of a disease or an organism, so disease, and reliance on a guide dog or a wheelchair or another type device. Okay, and it doesn't matter whether it was a pre-existing condition, whether it came from birth, or whether it previously existed and no longer exists. As long as the person has one of those attributes, under the Queensland law, they're going to meet the definition of someone with a impairment, is the Queensland way of referring to it. So under the DDA, they refer not to impairment but rather to disability. And again, it's total or partial loss of a person's bodily or mental functions, and total or partial loss of part of a body, the presence of an organism, so very similar wording again when they refer to diseases, and the presence of an organism capable of causing a disease or an illness, malfunction, malformation. It really, there's just been some tweaking rather with regards to the two acts. It's I think when the Commonwealth designed their legislation a year later than Queensland, that they even borrowed from the Act, because the wording's so similar. So that's our definition of a disability. Now, Queensland also are concerned with the issue of direct discrimination, which you'll note that the Commonwealth Act doesn't refer to. So in looking at direct discrimination, Section 10, of course we're coming, goodness me, I'm just throwing pages everywhere. Section 10, direct discrimination is on the basis of an attribute. If it happens, it happens if a person treats or is proposed to treat a person with an attribute less favourably than any other persons. So the legislation does give us an example. It refers to something that's broader discrimination, because of course the Queensland Act isn't particular with regards to a disability, and they're referring to a racial discrimination. So R refuses to rent a flat to C. C is English and R doesn't like English people. C's friend B is English and R doesn't like English people. R believes that English people are unreliable tenants. It's a very broad type of discrimination, but really when looking at disability discrimination, it can present itself in so many different ways. Now, moving on to indirect discrimination. Indirect discrimination under the Queensland legislation is on the basis of an attribute a person imposes, or they impose a term which a person with the attribute doesn't or isn't able to comply with, or a higher proportion of people without the attribute comply or are able to comply with. So it's certainly the descriptions are coming out less direct, and that's just unreasonable is the final definition there. Whether a term is reasonable depends on whether the relevant circumstances of the case. So it is referring to whether there can be reasonable adjustments made. Reasonable adjustment, if it's something that you're not familiar with, we'll come to it slightly further down the track. For the purposes of the Act, looking at the Commonwealth Act, Section 6, describing indirect discrimination, for the purposes of the Act, the discriminator discriminates against the person, the aggrieved person, on the grounds of a disability if the discriminator requires or proposes to require the aggrieved person to comply with a requirement or a condition. Because of the disability, the aggrieved person does not or would not comply, and is not able or would not be able to comply with the requirement or the condition. And the requirement of the condition is likely to have the effect of disadvantaging the person with the disability. So Section 5.2 actually goes direct to a failure to make a reasonable adjustment under the Commonwealth law. So 5.2 specifically refers to making these minor adjustments, and whether it would be reasonable in the circumstances for the adjustment to be made. There's a little bit further through the Act, there are references to exceptions, and we'll come to those. The ADA refers to, which is the Queensland Act, does refer to require special services or facilities, and that's their definition of making reasonable adjustments. So special services or facilities, it's not this is under, of course, the Queensland Act, it's not unlawful for a person to discriminate on the basis of an impairment against another person with respect to a matter that's otherwise prohibited if the other person would require special services or facilities and the supply of special services or facilities would impose an unjustifiable hardship. So if a business or an employer is looking at making a reasonable adjustment, one of their exemptions may be that they can claim that it would cause unjustifiable hardship to the business. It could be that it's always going to come back to the facts of the case, but it could be that putting in a wheelchair ramp is really just as simple as making a small ramp at the front door, or it might be that it's a heritage listed building and to try to make the reasonable adjustments would blow out expenses. It's a poor example because most people have been able to overcome wheelchair ramps. Now, it's under the Commonwealth Act in the interpretation, and it's actually much briefer. It's just an adjustment, reasonable adjustment. An adjustment to be made by a person is a reasonable adjustment unless making the adjustment would impose an unjustifiable hardship. It's said simply that both the Commonwealth and the state are in agreement that there is an exemption if a reasonable adjustment would cause that hardship. So the definition of work or employment is available in both of their, the Commonwealth and the state interpretations or dictionaries, and it's just the Commonwealth only recognises part-time and temporary employment, work under a contract, work as a Commonwealth employee, or work as an employee of the state or an instrumentality of the state. However, the Queensland legislation is much broader and recognises people that are doing unpaid work, volunteers, people that are working on a vocational placement, people that are doing work experience. They refer to statutory appointments, people who are just working on a commission basis. I'm just planting some seeds here we'll come back to a little bit later. These are of course going to be decisions about which jurisdiction you might want to pursue a claim in. So discrimination in work or pre-employment. So discrimination in the pre-work area, of course we're talking about someone's applying for a job but they haven't got it yet. So you can't discriminate when you're deciding who should be offered a job. This is section 14 of the ADA. In deciding who should be offered work or in failing to offer work. And section 15 is a person mustn't discriminate in terms of work or denying or limiting access to opportunities, so promotions and so forth, in dismissing a worker or denying access to a guidance program, occupational training or retraining program. Under the Commonwealth, the definition is actually quite similar. It's just a little bit more wordy and lengthy. So they talk about it's unlawful for an employer to discriminate against a person's disability in the arrangements made for the purpose of determining who should be offered employment and determining who should be in determining who should be offered employment or in the terms or conditions of employment that are offered. Moving on to vicarious liability, both the Commonwealth and the state have recognition of other people who work within the program, people who have mandated employment. The Commonwealth define it rather tidily. They squeezed it into section 15, and the State Act just broadened that into. Sorry, I don't know whether you guys can hear that. They're doing some renovation work downstairs after a fire. So it's person or workers or agents contravene the Act if in the course of work or while acting as an agent they contravene the Act, and they are jointly and civilly liable. So it's not just that the Anti-Discrimination Act or the Disability Discrimination Act pose obligations on employers, but other people who work within the organisation via vicarious liability. So then there's genuine occupational required and inherent requirements. These are, again, exemptions. So they refer to if a job has a requirement that the person with a disability would just not be able to achieve, even with a reasonable adjustment, then it's not discrimination and it's not unlawful to discriminate against a person on the grounds of their disability. So under the DDA, they say if the discrimination relates to particular work, if because of the disability the aggrieved person would be unable to carry out those inherent requirements. They also put forward some factors under Section 2 where they say the aggrieved person's past training and qualifications need to be considered. Can't just be a quick glance that you summarise that a person with a disability couldn't perform that work. And if the aggrieved person already works for the discriminator, then their work performance. There's a few other factors that they go into. Just looking at the Queensland ADA, they put forward some further, because of course it's a broad act, it's not specifically discrimination, they refer to a person may impose genuine occupational requirements for a position. They also talk about religious bodies being able to discriminate. And discrimination isn't unreasonable in the circumstances if action taken or proposed to be taken by an employer is harsh or unjust or disproportionate to the person's actions. If the discrimination has or hasn't happened, if it's been planned to happen. So just moving on to compliance with other legislation, it just says that exemptions within other areas of legislation would carry over into this area as well. Public health, both acts, state and Commonwealth, allow for discrimination based on public health interests and workplace health and safety. The last piece of the Commonwealth legislation that I wanted to refer to before we move on refers to special services. It's not unlawful to discriminate on the basis of an impairment if the action was otherwise prohibited. Unjustifiable hardship is mentioned again. I guess, how could I put this into an example? So if someone was exposing themselves because they felt that an aid that they were using or a tool that they required to deal with a disability meant that they were showing their privates, it wouldn't be unlawful to say you've got to cover up. And it wouldn't be a defence for the disabled person to say I can't do this job and cover up. I do want to just quickly make a reference to the Fair Work Act, and if any of you have any experience in employment law, it's general protections that we're going to be focusing on. In fact, Section 351, I'm not going to start reading that legislation, you can all take a sigh there, but there will be reference to general protection applications. So now I've bored you with the legislation, I want to get into something a little bit more interesting. So a person comes to you, they seek advice, they say I've been discriminated against on the grounds of my disability. So when you're talking to this client, it really is important in disability discrimination matters to identify the main issues at the outset. The applications that you make really do need to hit the nail on the head at first instance. So the list of questions that I want to put forward would be, is the client still employed or has their employment been terminated? This is going to be really relevant because I'm considering a general protection application at first instance in every discrimination on the grounds of disability matter. And there's a time limit with regards to the Fair Work Commission general protections applications, which is if the person's been terminated, they've got 21 days to lodge a claim. and the Commission's not very forgiving with requests for extensions. Now I'm going to ask who's the employer, and I'm considering whether it's a government employer, whether that's state or Commonwealth, or an agency of the same. I'm considering which jurisdiction we might be pursuing. Now I'm asking the client whether their employment's full-time, part-time or casual, and whether it was with or without a contract. This is really just about evidence. General protections don't have a minimum employment period like, say, an unfair dismissal does. What was the other party? Was the other party involved? Was any other party involved? Such as some businesses will have parent companies that may be giving directions. It could be that the other party is not actually the employer, or maybe there's a second other party. Now I want to start focusing on some evidence. What paper trail exists? Did you get several emails that could evidence your discrimination? What is the disability, and was the employer aware of it? Because if you just kept your business together for quite some time and no one ever knew that you had this mental health issue, which you can't always see, it can be controlled, it maybe never posed a problem before, these are things that might be really relevant. Was a reasonable adjustment to accommodate the disability requested? Did you ask for shortened hours, a tool, assistance with something, to be relieved of a particular duty? Was it verbal or in writing? This is of course important for putting the employer on notice. And does the employer have specific policies relating to disability, diversity, reasonable adjustment, disciplinary processes or internal grievances? And if so, it'd be really good if the client could provide us with a copy of those. If they've already left the employment, it might be something that we request at a future time. Now I really wanted to give some practical steps, because a lot of people, if you did any reading on the internet about disability discrimination, it tends to be quite firm with regards to it's not acceptable, it's unlawful, and of course it is, but then there's a lot of information about judicial bodies, commissions and tribunals and so forth. But if you're a solicitor in a community legal centre, of course we're generally looking for quick and attainable justice for our clients, and if you're a person with a disability who has employment, a practical step would be write to the employer, state the client's instructions, state what legislation requires, and then state what remedies you seek. It could be beneficial in lots of ways. It could identify evidence that you're going to need if you do have to follow more of a litigious path. It's going to save time if the matter is resolved promptly. It's going to get you a reply from the other party, which hopefully will at least narrow some issues or clarify some matters. Not saying that the client gave false instructions, but maybe there were other things that the client was unaware of. It can also, depending on whether the client's still employed, preserve their employment relationship. We'll just move on to jurisdiction. So which jurisdiction to choose? If you've got a matter of disability discrimination, you should generally be looking at a Fair Work Commission application, and it's going to be a general protection. There's some benefits to this. If the client was terminated, you've got 21 days to lodge. If they're past the 21 days, you might be looking at another jurisdiction, another forum. If the client wasn't terminated, you've got 6 years to lodge an application for a general protection breach for disability discrimination from the date of the cause of action. Once you've entered a general protection application within the Fair Work Commission, they have to respond. And if you do start an action, say, in the ADCQ or the Australian Human Rights Commission, the other party doesn't necessarily have to respond before conciliation. So at least commencing your action in the Fair Work Commission as a general protection means that you can flush out the response of the other party. It might also mean that your conciliation is looking a little bit more positive for a settlement, because the other party is actually pushed to show their hand beforehand, before the conciliation, and you might be able to reach an agreement. Now, if conciliation isn't successful, a certificate's going to be issued. You'd now have an option that you could go on to the Federal Circuit Court under the Fair Work Commission processes. You can also make an application, as long as you're within the 12-month time limit from the cause of action. You could make an application to the ADCQ or the Australian Human Rights Commission. And once again, you're going to have another opportunity to conciliate. And I'll talk in a little bit about where you'd go from there. So, of course, there's many reasons for discrimination to occur, and often someone that comes to you claiming that they've suffered disability discrimination will also be able to report that there were other types of discrimination that they've suffered. Now, if you're making an application to the ADCQ, then the substantial reason needs to be disability discrimination. If you're pursuing the Australian Human Rights Commission, then disability discrimination just has to be one of the reasons. Now, when I was going through all that legislation of the DDA and the ADA, one of the things I pointed out was that the Commonwealth don't include volunteers as workers. So if your person complaining of disability discrimination in the workplace was a volunteer, they'll have no standing in the Human Rights Commission. If the employer was a Commonwealth entity, you'd really need to be looking at the Fair Work Commission or the Australian Human Rights Commission. If the employer is a state entity, then you could be looking at the Queensland Industrial Relations Commission, the ADCQ, or the Australian Human Rights Commission. Now, evidence, because of course everything's going to be evidence. The second point does say that Section 204 of the ADA refers to a balance of probabilities. And of course, any legal matter is going to come down to how you can evidence it, because it's going to influence how the decisions are made. Now, as much as the client's going to have the balance of probabilities, the employer's also got the same standard to prove either an exemption or that they have a defence. I'd be advising a client at very early stages that they're going to need to obtain medical reports to link an action and any injury suffered, and it's also going to be really important later down the track to determine a quantum of what their claim is. A lot of clients that I've come across, maybe they just want to self-report. It's just going to lower their quantum. It's not necessarily going to cause damage to their action, but it certainly will lower the amount that they're going to be able to claim. And witnesses or supporting statements. And I've also had a lot of clients that didn't want to approach witnesses. They felt really uncomfortable. Like in any matter, you've got to be able to evidence it. So you really need to advise clients. And with regards to any witness in any jurisdiction I've ever worked in, I've always thought striking while the iron's hot. People might remember an incident that happened in the last week, last day, but once you hit 9 months, you might be really hard pressed to get anyone who has any probative value in their witness statements. So there was a case of Bringenshaw and Bringenshaw, and I won't really go into the case too much, but this was just from the case, and the case itself was a divorce case, but it was this quote, and it's, "The tribunal needs to feel an actual persuasion of its occurrence or existence before it can be found. It cannot be found as a result of a mere mechanical comparison of probabilities independently of any belief in its reality. At common law, it's enough that the affirmative of an allegation is made out to a reasonable satisfaction of tribunal, and it's been said that the balance of probabilities in disability discrimination matters will rely on the principle of Bringenshaw and Bringenshaw." That's why I raised it. So a client's claim. Any claim has to be structured from the outset quite well. Once a matter's been referred to the commissions, you're not going to be able to make any additions. The key case there was Arnold and Compass Group. The other thing that I wanted to impart upon you all was that Crown law won't settle after an unsuccessful conciliation. So if the other party is Crown law as the employer, you need to make your first conciliation worthwhile. And if you don't, the only way that your matter is going to get a positive resolution for your client is to complete a hearing and to have success at the hearing. And in particular, given that we're in the community legal centre sector, once matters go on to hearing, clients are generally unrepresented. So if there's any capacity to help a client through a conciliation process, and I know that Caxton do have their referral and support through the conciliations of the Fair Work Commission up and running, it's really important that the client's initial application is just nailed. If your matters are progressing, QPILTs do have the capacity to get counsel advice. Hope that you can all make use of that. So I just wanted to sort of wrap it up with something a little bit more tangible so that you could maybe understand how you would actually progress a matter, because disability discrimination is a little bit fiddly. There's so many different rules and considerations of the state or the Commonwealth legislation, which jurisdiction to take. If you try to do your own research, you'll find that there's lots of references to all of the different forums that you might be able to progress a matter to. So this is it in its simple form. You're going to take your client's instructions. If you were to use the questions that I put forward earlier in the seminar, you'll actually find that they're of great benefit to you. They were devised by a disability discrimination solicitor. So you want to assess the claim, assess what evidence you'd need to gather, including whether there's any witnesses, and of course encourage your clients to approach those witnesses and get into the evidence gathering quite early, and also to determine jurisdictions depending on who the other party is and what the client's circumstances are. If they're a volunteer, if their employer was a government agency. Right to the other party, many disability discrimination matters that I've been involved in resolved just by writing to an employer and just seeking a fast resolution. If you do have to go on to filing an application, Fair Work Commission for General Protections is the application that you want. If the client was dismissed, it's a Form 8. If the client's not dismissed, it's a Form 8C. Of course, if a client's been dismissed, I would be really paying heavy attention to that 21-day time limit, because it might mean that your first few steps are shaped by how much time you've got. Now, once your conciliation's completed and you're issued with a certificate, you then want to be looking generally, depending of course on the client's circumstances, at the ADCQ. The ADCQ does have a capacity to refer matters to QCAT for hearing, and I would much rather see a client undertaking a hearing probably in a jurisdiction like QCAT rather than the Federal Circuit Court, particularly if they're unrepresented. Now, I just had a couple of cases that I wanted to run over with you. So the first is the New South Wales Department of Education case of Smith and the Department of Education. Now, some of these cases are of course out of Queensland, but they're not necessarily recent cases, but they're precedent cases, I guess, that have really shaped some disability discrimination decisions in other states and territories and at the Commonwealth level as well. Now, I'll just run you through the facts really quick. So this matter went through the New South Wales Administrative Decisions Tribunal. The employee is Smith, and Smith had a back injury, and it was accommodated for at work. He'd been working for the Department of Education and Communities for over 5 years. He had an unsatisfactory meeting with 2 superiors, and his doctor diagnosed an adjustment disorder with anxiety. So because of that adjustment disorder with anxiety, Mr. Smith had to take some time off work. He was ready to return to work, and the Department of Education wanted to put him into a school that was in the Darlinghurst area, so that's in almost the centre of Sydney. He had been at a school that was in Parramatta. How do I describe that? Okay, if you were driving in a car, it's more than an hour's west. He wanted to return to his school at Parramatta, and he was arguing that my pre-existing back condition, there's already been reasonable adjustments made at the school at Parramatta, and further, if I have to go into Darlinghurst, it's going to put me really close to these two supervisors who I had a dispute with, and it started my adjustment disorder. So his doctor had, you know, backed him up in his claims, and so he has a year off work. There's a lot of correspondence back and forth between the doctor and the employer, and you know, it's been almost 18 months that he's been off work at this point, and he was allowed to return to work, but the school was, or the Department of Education rather, was forcing that he sign a return to work plan that the employer prepared. And the plan differed from a previous return to work plan because it failed to distinguish between his psychological injury, which was new and caused by work, and also had Smith off work all this time, and the pre-existing back condition. Mr. Smith, actually I don't know whether it's Mr. or Miss, but Smith refused to sign the work plan. So in the New South Wales Administrative Decisions Tribunal, it was found that the employer unlawfully discriminated against Smith by refusing to allow him to perform his duties and to earn an income, and because he refused to sign the return to work plan. It was also found that the employer wouldn't have taken this step with another person in the same circumstance, but with his pre-existing back disability was taken into account. So Smith ended up getting awarded $38,000 for pure economic loss and $2,500 for emotional distress. So I'll move on to the next case, which is the Silver and Rogers, and it's an accountant who actually had to have heart surgery. And so the crux of the case was the applicant was dismissed for health-related reasons, and it left the employer open to an adverse action claim. The matter went through the Federal Magistrates Court. It was 2012, and the court found that the employer had contravened the Fair Work Act by dismissing the employee for these health reasons and failing to, this is secondary, failing to pay termination benefits in lieu of notice. And the Federal Magistrates Court ordered that the employer had to pay the benefits and 3 months of pay past interest, and there were other penalties that were imposed. And the court ruled that the employee had been subject to the adverse action when he received the notice of termination and was dismissed in the same day. It didn't accept the employer's claim that there was an economic downturn. The claim of the employer was that it was a redundancy. It was the same day that the applicant notified his employers that he had this heart condition and he was going to need to have some reasonable adjustments made, that he was terminated. So it's sort of one of the key elements there was proximity. Indeed, there was an economic downturn at the time, but it was just able to be argued that the coincidence was just beyond a coincidence. So without a heavy amount of witnesses or written evidence, that matter was able to progress successfully. So I wanted to give you a bit of an example of underpayment, because often you know, there's all sorts of disability discrimination, but also people being taken advantage of who are in a vulnerable position. This is a Fair Work Ombudsman matter, and it's the case of a receptionist who had an eye, was a detached retina and cataracts, and she was only, in the period of her employment, she was between the ages of 18 and 21, so it's exceptionally unfortunate at such a young age to have such a degenerative eye condition. But anyway, so initially it was her doctor who had offered her the employment within the medical centre. There were two brothers. It was, again, it's another New South Wales matter, but of course Ombudsman, so it's a federal jurisdiction. She's offered the employment. She's paid between $7 and $8 an hour, just a flat rate. when the matter went through the Ombudsman's office and the FWO investigated, she was entitled to $10 an hour for normal work within her first year, not 7, and she was even entitled to up to $17 an hour for some of the weekend, public holiday and overtime work. They, the employer was basically just taking her for a ride. So this is a disability discrimination matter where, of course, the matter was referred to the FWO. Any matter where I had a client who was underpaid, I'd refer to the FWO, but they relied on some disability discrimination legislation when prosecuting this matter. So the next is, with regards to a local counsellor, it's discrimination on the grounds of the medical condition of hepatitis C. It's Matthews and Hargraves, and this is quite a colourful matter if you ever wanted to read it, or I don't know, have a laugh or a cry. But so the applicant is Mr. Matthews, and he's the former chief executive of the Shire of Shark Bay, and he's employed by the Shire in January 2006, and he's got a 5-year contract. And he alleged that Hargreaves, who was elected as a Shire councillor in 2007, engaged in unlawful discrimination in contravention of the Disability Discrimination Act, so DDA, common law. And Matthews claimed that Hargreaves discriminated against him on the grounds of his disability, which is Hep C. Hargreaves issued and circulated a statement concerning the CEO's hepatitis C via email, fax and letter drops to the community of Shark Bay. And it read verbatim like this: "I've been given to understand from a seemingly reliable source that Mr. Matthews has hepatitis C. This information is not given to you because of a perceived personality problem, as you so often suggested between Mr. Matthews and myself, but as a duty of care and responsibility, as not only a counsellor, but as a private citizen." I'm not quite sure why he thought that he should be telling all these people about the hepatitis C, the CEO. That wasn't really put forward. Anyway, the case isn't so much about those facts, because look at that, it just makes me smile at anyone who'd be so dumb as to start circulating that sort of notice, particularly when they're meant to be a counsellor. But there was a declaration of an apology sought from Hargreaves. There was an amount of $10,000. There was a deed of settlement that was produced. And then the matter was still pursued after the deed of settlement was executed. And so the matter went on to the Federal Circuit Court. The issue was with regards to the construction of the deed. It was said to be too broad, so the plaintiff was able to continue his matter even after he'd signed the deed. And so the Federal Magistrate, Luciv, noted that the terms of the release were very broad, and so she focused on the consequences of the deed and how it allowed Matthews to pursue his matter. It was sort of said that in drafting deeds of release that they need to be done carefully, that often deeds are drafted quite broadly, but they need to be a lot more narrow, and particular care should be taken when identifying the claim to be covered by the deed, and consideration should be had to the use of phrases such as employee and agent and servants, and with regard to the release and the accurate and the rights and the interests of all the parties. It was just, I just find that reading that case is just an appalling display of discriminating against someone's medical disability. So moving on, I'll move on to a hospital worker who was bipolar. It's Collier and the Austin Health and others in 2011. It's a Victorian case, and it does refer a lot to the Charter of Human Rights and Responsibilities Act, which is Victorian legislation, but it's not all just locked into Victorian law. I'll just read some of the facts. It was so the facts are that Mary Collier, she'd been a food services worker at the Austin Hospital for 10 years, and throughout that time she'd suffered from a bipolar disorder. She'd had a breakdown once earlier, and in late 2005 Ms. Collier was placed under a lot of pressure at work. She had a lot of hours, and there was a health breakdown. She spent nearly 2 months in hospital, and following her recovery, she sought to enter the hospital's rehabilitation program and gradually return to work. And the hospital allowed her to do this in the earlier breakdown that she had in 2004. But after her late 2005 breakdown, they refused to rehabilitate her, and they terminated her employment in 2006. And at all times she was arguing that she was fit and willing and able to return to work. So whilst there was quite a lot of comment, as I said, about the charter that's specifically Victorian, there'd been an error in QCAT when they were trying VCAT, when they were trying to apply a hypothetical situation, such as like Miss Collier was treated adversely because of her disability. VCAT were trying to determine how would we look at this matter if we were looking at someone who didn't have that disability, and basically they just mucked up. So the matter progressed on to the Victorian Supreme Court, and Justice Bell referred the matter back to VCAT, saying that the relevant comparator for the purposes of a hypothetical person with a different type of impairment who was also seeking access to a rehabilitation and graduated return to work program could have been applied and should have been applied, and it was the case that VCAT were just saying, oh, this is really too hard because these are such specific circumstances. And so it really did open up a lot of future applications for disability discriminations in other jurisdictions, and it's a case that's been referred to for some time in all jurisdictions, including Commonwealth. So the last matter that I wanted to refer to, and I'll just touch on it briefly, was the matter of Davies in the state of Victoria. And it's sort of a little bit different to the others in that the plaintiff is Mr. Davies, and he's employed by the Department of Human Services. He's a disability worker or support worker. And in his matter, he was found to have committed excuse me. He committed a serious misconduct when he was caring for a patient who was very mentally unwell. The patient was naked, and he dragged the person across floor in this supported accommodation in the community situation that the patient was living in. The patient suffered some burns and some abrasions, I think it was knees and heels, and also his buttocks. And anyway, the case was argued that Davies hadn't acted outside the scope of his employment. There was a finding in the end that it wasn't reasonable to be dragging this disabled person across the floor, and this really became a key case about dignified treatment of mentally ill patients and warranted dismissal. It was deemed that it really came down to whether there was appropriate equipment in the house, whether there were proper adjustments made to the house, and how disabilities can not only be employees with disabilities, but the carers of people with disabilities. And it sort of shaped some of the disability discrimination law, because whilst this was the perpetrator who was being terminated and was taking his matter through the Victorian Supreme Court, there were a lot of principles that were applied in this matter from the Charter of Human Rights and Responsibilities in Act in Victoria, but also some similar legislation was applied sort of in a reverse manner during this case. So I want to thank you all for listening. Oh my, I didn't realise that I spoke for so long. Were there any questions that anyone would want to put forward at this time? No? Okay, well, look, I'll just say thank you all for listening, and I hope that I was of some help. I will make my PowerPoint presentation available to Quails if anyone wanted to follow up and grab a copy. And you all have a good afternoon.
Great, James. Thanks so much for presenting to us. It's particularly interesting, some of those case studies that you put forward. So thank you everyone also for coming along and hearing James present. You'll be sent a survey after the webinar concludes, so you can give us some feedback on what you learned and what you got out of it and what you'd like us to present webinars on in the future. So thanks again, everyone.